years. We have just gone through one of the biggest changes to the patent laws that have ever happened. After 240 years of being a first-to-invent system, the United States has now gone to a first-to-file system effective March 16, 2013. That means that for the first 240 years of our country's history, whoever was the first person to discover or invent something was entitled to the patent on it, even if they filed their patent application later than another person. Now, as of March 16th of 2013, the first person to file their provisional patent application is the person that is entitled to the patent. The good news for the inventor and the researcher today is that in making this change, the United States did not stop allowing provisional patent applications. A provisional patent application is a much briefer form than a regular patent application. Many people think that because it is a brief form, it doesn't fulfill anything other than a space saver service. What I mean by that is people will call up and they will have filed a provisional patent application where they simply put it in to briefly describe their description, and then what they want to claim is broader than that, or it's changed somewhat. Every patent application filed as a provisional application should have three cardinal things done prior to filing. Number one is the description and any drawings necessary to understand the description. Everybody understands this. This is, if you look at forms banks that tell you how to file a provisional patent application, what they're asking for. Describe your invention and include any photos or drawings that are necessary. Frequently, though, the vast majority of provisional patent applications that get filed by inventors and not by major corporations get filed without putting enough thought into what they're doing. Every time a provisional patent application is filed, an English language search should be done to find out what the other art is out there prior to this application. The other thing that should be done prior to filing your provisional is to draft your claims ahead of time. You don't need to draft exhaustive claims claiming everything that you're going to be doing. You need to have a broad set of claims and some narrow claims to help you differentiate what you have from every other patent out there. Now, most of the people who call me tell me, well, Michael, I've looked at this and nobody else has this idea. And I tell them, go to the Patent Office website and start looking at some patents that have been issued. What you're going to find is that in every patent issued over the last 200 years, the patent examiner cited usually 1, 2, 3, or more patents of similar art. Those are what you need to look at. It's not simply a matter of figuring out whether or not what you have is identical to what's out there already. You need to find the patents that are closest. You need to have an experienced either patent attorney or an experienced researcher go through and find the patents that are closest. You need to draft your provisional based on that. It's a common misconception among the public that once you file your provisional, it's a space saver, and after filing it, when you get ready to file your real non-provisional patent application, that you can make changes to your provisional. You can't. You only have the description in your provisional patent application to work from. If the claims that you're later filing, which define what your patent is, the claims define what your patent is, if those aren't supported by your description, you can't claim them, even if, had you properly drafted your provisional patent application to begin with, you could have.